Well, the big hand and the little hand are both on the number 12. So, David, shall we begin?
We shall indeed. And Matt, I don't know what you've done with your background, but it is incredibly impressive, whatever it is.
I've moved to space. It was easier.
That's good. Well, good afternoon, everyone. Thank you for joining us for this webinar about business continuity. In common with others, we are making more use of webinars and video conferencing, and we wanted to share some of our knowledge about business continuity during this terrible time. Most of the webinar shall be presented by my colleague, Matt Howgate. Along with my co-director, Melanie O'Brien, Matt's worked very hard on writing guidance and various documents and templates for our clients. I shall start, though, with a few introductory slides, and shall also comment on some suggested free software which may assist you. Okay. Now, please ensure that you've muted your microphone. We have enabled sound for this webinar, and that's because at certain points we will invite questions. However, given that we have well over 200 participants, we may need to control the number of questions. It's well over 200 that are booked. If that happens, we'll say so, and we'll invite you to send an email to info@dglegal.co.uk, and we'll then compile an FAQ and email the document to you. You may find that Matt's face covers part of the slide. If that's the case, as we put in the slide, just simply drag the presenter video box to the corner of the screen so that you can see the slides fully. Okay. Now, we originally planned this webinar to be around 30 minutes. However, it will be closer to an hour, especially because of questions and answers. We don't think that this is a problem, given that people can leave whenever they want to. So we'll be covering, should you close your office, managing home working, supporting existing clients, suggested free software, staff furloughs, government financial support, and business continuity plans. And on the right-hand side of this slide is a snippet of a fairly detailed briefing about business continuity that we sent to our clients. Okay. By this stage, your office should probably be closed, unless there's a very good reason for it to be open. The government's advice is clear that where possible, everyone should be working from home. Keeping your office open when it's absolutely not essential clearly puts you, your staff, and others at risk. If your office is still open, then you need to ask yourself whether that's really necessary. If it is, then are as many staff as possible working from home? Could more staff be working from home? Police will be reassured if staff are working from the office because they are so-called key workers. Okay. You will have probably seen this definition of key workers in relation to the legal sector. And I'm not going to read out those bullet points. You can see them clearly in front of you. We have been asked on a few occasions, though, whether this definition applies equally to civil practitioners such as family lawyers. The answer is yes, if you are required to attend court in person. We understand, though, that many courts this week are moving to Skype and other video conferencing methods. I'll hand over to Matt now to go through some more of the detail.
Okay, so as David said, by now your office should be closed unless there are very good reasons why it should stay open. And it's probably worth mentioning that the regulations covering the restrictions applied to individuals are now on the government website and are already passed through Parliament in the normal way. But you need to be cautious of them because they do impose significant restrictions on movement. I think, as the government have said, these are the most significant non-wartime restrictions ever imposed on the movement of individuals in this country. And police are now stopping people. I've had a couple of reports this morning from clients of staff being stopped and asked what they're doing, so it's worth thinking about that. The regulations make clear that the valid reason is to travel for work, but only where it is not reasonably possible for that person to work from home. That means that if it is possible for the person to work from home, that's where they need to work. Now, that might mean they have to pop into the office from time to time to collect stuff, or that you have to arrange for things to be collected, but ultimately staff should be working from home unless there's a very good reason for them not to be. I don't think a very good reason is that it's more convenient for you to keep the office open or for them to work from the office, so just be careful with that. So, if you are having to keep the office open, and there may be circumstances where either temporarily or otherwise you have to keep the office open, make sure you follow the latest government and other online guidance. So in terms of staff or others travelling to the office, try to avoid the use of public transport unless it's absolutely necessary. And if it is necessary, try to avoid the use of public transport at rush hour. Obviously, there are significant reductions in the availability of public transport in a number of cities at the moment, so be very careful. Even at work, ensure that you are respecting the social distancing rules and that staff, and if you have to see clients in an emergency, clients are 2 metres away from each other. I realise that may be difficult, but again, you know, the reality here is we've all got to be incredibly careful because the person that you infect might not infect somebody else, but the people they infect might, so it's incredibly difficult. Make sure, if you can, you're using hand sanitizer, although bluntly there's been terrible price gouging online in terms of getting hold of this. And as far as I can see, unless you're willing to sell your firstborn, it's practically impossible to get hand sanitizer at the moment, but if you've got some, make it available. But in any event, make sure that staff and visitors have access to hand washing facilities and that they're washing their hands frequently. Appointments should only be conducted face-to-face if there is no viable alternative and the matter is urgent. So I think we're all discovering that our reluctance to embrace technology in the past was perhaps short-sighted, and there's more you can achieve by telephone and Skype and Zoom than you might previously have imagined, so think of those first. Make sure that you have increased cleaning in the office if you have to keep it open, even if it's just temporarily. Make sure you're cleaning surfaces and disinfecting as best you can. And obviously make sure waste bins are being emptied, particularly if they've got things like tissues and other wipes and things in there, so make sure they're being emptied. But I think our key message is if you can close your office and keep it closed other than essential popping in to pick up files or post or other bits and pieces, then you should do so. I think it's probably fair to say that at some point during this, if you haven't already got staff who are ill, you might have staff who are ill or who are at least showing symptoms and who therefore may need to self-isolate. So at any point, if you have staff or yourself showing symptoms of coronavirus, then follow the government's guidance and ensure that you or they self-isolate as appropriate. And please remember that self-isolating because you're ill doesn't necessarily mean you're also available to do work. So you need to think about that. Obviously, apply all of your normal health and safety rules as you would do generally. Managing working from home, I think this is going to be a challenge for all of us. Certainly the experience I've had over the last few days is that understandably people made very significant decisions very quickly in relation to home working in the last week or so. And it sounds to me from the government's recent update that we're probably going to have to dig in for the long haul here. I wouldn't be shocked if we're locked down for significantly longer than the 3 weeks they originally anticipated. Depending on which news outlet you listen to, it's 12 weeks or longer with a review every 3 weeks. So this could become our new normal, certainly for the foreseeable future. So we need to make sure that the quick decisions we took in the last week or two translate into more thoughtful decisions over the next week or two, because we might have to be dealing with this situation for a much longer period than expecting. So what we'd suggest is in relation to each staff member, and you may not have had the chance to do this before, undertake a home working risk assessment, and we'll come back to that in a moment. Think about data security. It's really important. The Information Commissioner's Office have been very clear. They will be reasonable, but they still expect you to take data security and confidentiality extremely seriously, as do the SRA. So you can't just assume that all of the rules in relation to this are out of the window whilst people are working from home. That's not how it's going to work. Think about tech, both hardware and software, and about phone access. Do your staff have the tech that they need? Do they have the computers? Do they have the ability to access the software that they need in order to do the work that you're asking them? And that may not just be things like access to your management system, it might also be things like access to legal research tools and other software that you might use. So take a breath, stop, think about what access and technological solutions people need. David's going to talk a bit about some free software that might help in a while, but again, now's time to reflect on those things. I know this is probably something that's to put in a box for a while, but do think about the cost to your employees. You've effectively shifted some of your overheads into their houses, and so you do need to think about whether that's creating additional cost to them in terms of calls and broadband usage and other bits and pieces. So you might want to park that one to consider later, but it's something that's worth thinking about. Think about what will happen if your employees get sick whilst in possession of client files. Now, some of you will be largely electronic working and you won't have physical paper files. Some of you won't be, and some of you will be in some middle area where you've got a lot online, but you still rely on some paper files. If your staff member takes the paper files home and then gets the virus or gets sick in some other way, how will you get hold of those files and how will you help your clients if those files are in somebody else's house, particularly if that person does get the virus? And of course you need to think about whether there's any risk associated with those files. So you need to think about that and think about how you might handle it if there's a problem. Obviously think about video conferencing. We're all online now. There are various pieces of software you can use. Again, David will talk about those later. But I think I've probably spent more time on Zoom in the last week and a half than I spent in the last 2 years. So do think about how you can best use that, both for speaking to your staff and for speaking to your clients. Think about supervision. Supervision's still important and you still have contractual obligations. And as you'll probably all know if you do legal aid, the legal aid agency have made some minor concessions, but they are still requiring proper supervision to be undertaken in accordance with the contract, subject to any reasonable adjustments for home working. So you do need to think about how you can ensure your staff are being realistically supervised. And that might mean you need to get particularly more junior staff to, for instance, email you copies of emails they intend to send out, particularly if those are significant or very important emails, or copies of any significant emails they receive. So we're not suggesting you routinely monitor all of your staff's emails, but there may be, depending on the risk associated with a staff member, certain things that you want them to send you for checking. And obviously do have online files. You can still do random file reviews for your staff or for the people you're supervising. Last of all, keep in touch with your staff. Working from home can be incredibly isolating. It is likely to have issues in relation to people's mental health in the medium to longer term, but it will feel lonely for a number of staff. So make sure you're keeping in touch with them. Remember, if you're in the office, people might walk past your door and say hi, or you'll see them as you're making a cup of coffee, or you might just pop in to have a chat with them, which of course you can't do. So give them a call, arrange regular video conferences with your staff, just to make sure that they know you're thinking about them and you know that they're doing what they should be doing. It's probably a good time to invite questions. I'm hoping people are able to ask a question, but would somebody try? And if not, then obviously we'll have to divert back to email questions afterwards.
Yeah, Matt, this is David. I just wanted, I don't know if you saw it, but a box popped up from Nick Hanning, one of our colleagues, one of our colleague lawyers. And Nick had the very useful suggestion that, of course, post can be redirected to a partner's home.
Yes, absolutely. I think if you can do that, I'm not sure about the workings of redirectional business accounts, but it's certainly worth doing. Just to let you know, I'm not checking the pop-up boxes because obviously as a man, I can't multitask. So I'm just going to carry on with this bit. So if anything incredible comes up in the pop-up boxes, then David, you might need to ask. I don't think people are able to ask questions, David. I think everybody's muted.
I think that, yeah, I can see they're asking questions via the chat button. And I think what is probably going to be a sensible plan is to reply to all of those questions that are coming in through the chat portal via an FAQ email after the webinar is finished.
Okay, brilliant. Thanks, everybody. We'll move on then. Lastly, think about billing. It's fine to have people working from home, but ultimately you need to translate their work into money. And so you need to think about the implications of home working on your normal billing systems. And obviously, if you're doing legal aid certificated work and you typically rely on cost drafts people, then you need to be having a conversation with them and making sure that you can keep bills going in. We'll talk a bit later about the LAA's approach to helping you with cash flow. And obviously that does require some ongoing activity on your part. So you'll need to think about how that works. David, if you can monitor the queries coming in, if anything is critical, then you can add it into a question that you ask as we go along.
In fact, can I just, I will answer a couple of questions that I can see that have come up. One question is, if we furlough, do we need to retrieve computers, etc., from staff homes? I don't know whether she means homes or offices, etc. But Matt, could you just comment briefly on what you think should happen with computers, both at presumably at the office, but also at home?
So we're going to come to staff furloughing in a while. What's clear is that the staff member who is furloughed must not be working for you. So can we cover this when we come to the right part? Because I think otherwise we're preempting a part of the session that we're going to deal with later. So we'll come back to that, David.
Okay, carry on, Matt.
For those people who are participating in this who are DG Legal retainer clients, we have already produced and circulated for you all a home working risk assessment checklist. And we've also updated and created a home working policy. So again, if you're a retainer client, you will have received this already. If you're not a retainer client, then you need to email David at DG Legal and talk about whether you can find a way to access these through becoming a retainer client. But certainly if you're a retainer client, you've got these documents already. As things progress, all of our guidance that goes to retainer clients and all of our policies will be updated. Obviously, this is a live situation and we're adapting as fast as we can to make sure you've got the tools and information you need to do your job as best you can. Supporting existing clients is really important to remember here that you have ethical regulatory obligations to your existing clients and that you need to get this bit right, because I think that if you let down your existing clients, or at least if they feel let down, if they feel they can't get hold of you, if they feel that they're being neglected, regardless of this virus situation, they probably won't be slow at posting negative comments online or negative reviews. So make sure that you're thinking carefully about how you can look after your existing clients. First and foremost, let them know you're still open, if you are still open, and let them know that you're working on the cases if you're working on their cases. If you're not working on their case because it's non-urgent and you don't have the capacity because of staff sickness or absence, then tell them, manage their expectations. You need to be very clear with them. But remember, you do have a retainer with them. So if you're furloughing staff, if you're reducing your capacity, you still have ongoing contractual obligations in relation to the work for existing clients. So you need to think about how to balance that. Let them know about the impact of court closures and adjournments or the move to online or video hearings. You may have clients who've been expecting court dates over the next few weeks, and those court dates may well have been cancelled or delayed or maybe happening in different ways. Certainly, I've had queries over the end of last week about certain family hearings that have been adjourned, and that's causing stress to clients who felt that issues in relation, for instance, to the children might be resolved. So you need to be very careful to make sure you're keeping them informed about the impact or likely impact of any adjournments or changes in the way courts deal with hearings. Let them know how they can contact you. Now, it may well be that you've already redirected your main lines, or you've given your clients direct dial numbers which have been redirected, or you've given them mobile numbers. But if you haven't, think about how you do that. It may be that you need to take some time this week after last week's initial panic to try to make sure that you've told all of the staff, all of the clients who need to contact you, how they can do so. Let them know how they can get documents to you if needed. Now, obviously, don't bombard all clients with a random email about scanning and emailing, but if you have got clients that need to send you stuff, help them understand how to do it. Don't assume they know how to scan or file off and send you documentation. Many will, but many won't, so you might need to give them fairly easy instructions on how to get documents to you. And obviously, if your office is closed and you want to minimise visits to the office, try to stop them dropping stuff in, not least because that might not be considered essential travel outside of the home. So be careful not to encourage them to do that. Make sure you can keep on top of their cases, and that includes managing key dates and other limitations. As I say, it's probably okay for now, but if we see staff getting sick, then this may be more and more difficult. So think about your plans for dealing with their cases as the need arises. Have a backup plan, as I've already said, if staff do get sick. So you might need to think about who can take over somebody's urgent case, and make sure that staff are keeping you as principals in the loop in terms of what they're doing on cases, so that if they do get sick, you know you can step in or somebody else can step in and help out. If you're doing legal aid work, we have been working very closely with the Legal Aid Practitioners Group, and I've helped draft a piece of guidance for LAPG, which hopefully translates the LAA's own guidance in a way that is slightly more helpful, particularly around digital signatures. Now, at the moment, it's a bit civil specific, but we're hoping to broaden that to be more crime specific moving forward. So I've given you the link there to the LAPG guidance. And obviously you want to keep the LAA's own guidance in mind, so we've given you the link there. Now, I ought to say this, a little plug at this point for LAPG. LAPG is a membership organisation. They are doing an incredible job of trying to push the LAA to make concessions to help you do your work. So if you are not LAPG members, you really should think about joining. They're going to need your support now and after this. David, are there any questions that come in at this point that we can answer?
Well, people are asking a few questions via two different avenues. One is the webinar chat button and one is the Q&A button. There's an interesting question in relation to storage of files. Do we have any recommendations for how to store things safely and respecting confidentiality if we cannot pay for a locked cabinet for anyone? Would keeping files in a separate room like a study be acceptable, or keeping in a non-locked box with a lid away from the main living area?
Any reasonable thing that you can do with the resources available and given the limitations, because I'm pretty confident that if you tried to buy a small lockable cabinet now on eBay or on Amazon, you probably have to spend significant amounts of money if there are any available. So what you need to do, first of all, is talk to your staff member in the context of the risk assessment about data security of physical files in their specific circumstances. Now, obviously, some, it may not be a problem. They may have a separate home office with a lockable cabinet, or the door is lockable and that's not a problem. Some may be in a shared house or flat with other non-family members, and it may be much more difficult. So as long as you're taking steps to make sure that files are not left hanging around, that extremely confidential calls are taken if they can, in a separate room. And then at the end of the day, if files are then put away in your staff member's own room or in a box, or preferably in a lockable box, that should be enough. I mean, hopefully we're not going to see any significant data breaches as a result of this. If we do, the ICO is going to want to make sure that law firms did as much as was reasonably possible in the circumstances. So just be sensible about it. Okay,
there's also a question of what do we recommend for DX? Are people redirecting this also to senior solicitor? And will the LAA put sending files back via DX on pause? And I'll answer that one. Well, DX, of course, is an alternative to Post, and assuming that the DX have a redirection service, which I'm sure they probably do, then the answer would be yes. Will the LAA put sending files back via DX on pause? I would think so, but the thing to do with this particular question, I'm quite happy to do this myself, is you can tweet questions to the legal aid agency. There's 2 different addresses, and I think they're pretty good at replying because they're aware that all your followers are watching. Indeed, I sent a question to the agency this morning in relation to an automated Bravo email that went out yesterday warning crime suppliers that they only have 1 more day to get on the VHCC panel. Then my clear view was that this is an automated error, because Bravo has to have an end date, otherwise it can't function, despite the fact that the VHCC crime panel does not have an end date. You can apply for it at any time. So I asked them to confirm that, and they said that it would be doing so or providing guidance very shortly. So I think they'll also be happy to answer the question about pausing on sending files back via the DX. Someone else has asked or made the comment that they've sent their supervision plan to their contract manager twice and have had no reply, and wondered whether the fact that there hasn't been reply to her, that is indeed acceptable. Well, I'm not aware of the contract managers asking for a supervision plan at the moment. I may be wrong on that, and that may be the reason why the contract manager hasn't responded. However, it is clearly proactive of that questioner to have sent her supervision plan to the contract manager, and I think that's all to her credit.
Also, remember that the LAA is not immune to this. Contract managers may be self-isolating or away from work unwell. So that could explain it. So I wouldn't worry too much at this point.
Yeah, and I can see we've got a question about how to get on the VHCC panel. The answer is too lengthy to answer in this webinar, but what I'll do is I'll send an email to the person that's asked that question with the relevant requirements.
Okay, so now we're going to talk a bit about the government job retention scheme, which is when you furlough staff. And I want to be really clear from the outset here. Back in the olden days, I used to be a lawyer, and I want to do that legal thing of saying, look, everything we tell you now is based on our best understanding of the current government guidance, and we have cross-referenced that guidance where we can. We have not seen the final rules, and therefore, until we see the final rules, we want you all to be very careful, because certainly my inclination is that some of the things the government have announced in their daily press briefings have looked slightly different when translated into final rules or regulations. So some of the concessions that we thought they may have given were not quite as clear when we saw the final detail as there were. So let's talk about this, but remembering that this is based on the best information we have for you at the moment. If you intend to furlough staff, you might need to think about taking some specific employment law advice, and you certainly will need to think about looking at your staff contracts. So what this scheme basically does is allows you to lay off staff whilst still paying them, and then for you to claim up to 80% of their pay, capped at £2,500 per month, for the length of this scheme. So a furlough is basically a temporary leave of absence. And so there are some conditions that apply. The first one is the staff must be employed. Now, they can be employed full-time, part-time, on an agency basis or a 0 hours contract, but they must be employees. Somebody asked me over the weekend whether this applies to directors. Now, this scheme might theoretically apply to directors, because if you're a director of a limited company, for tax purposes, you may well also be an employee, but probably for not very much time and not on a very high salary. So whilst you might technically be both an owner, director and employee, the reality is you probably won't find much advantage of taking this scheme up if that's your position. But again, you need to talk to your accountant about what the best way for you to deal with this is. So this is a scheme for employed staff. In relation to the dates of employment, there are limitations on when a staff member can have started to be employed and the period for which this can be claimed. What I'd suggest you do is look at the government guidance on this, and you can find it by Googling the government or coronavirus job retention scheme, and you can find that. For DG Legal retainer clients, the guidance we issued last week already contains a number of this much of this information, and we'll be updating it this week. Staff must be fully furloughed. They can't work part-time. Now that's very clear from the latest government guidance. So you can't lay somebody off for 3 days a week and keep them working for 2 days a week. That's not how this scheme works. They're either laid off or they're not laid off. And if you want to take advantage of this, they need to be laid off for whatever working time. So if they're part-time, they need to be fully laid off for that part-time commitment. If they're full-time, they need to be fully laid off. Again, we haven't seen the final rules, but that's very clear from the government guidance, which was issued in detail at the end of last week. You must continue to pay your staff member. Now, the amount obliged to pay your staff member is a matter of contract between you and them. And you may be able to pay them less than 100% of their salary. You may be able to pay them the 80% or some other figure. Remember that the only contribution from government is up to 80% of their salary, capped at £2,500 per month. So you need to think about what somebody's salary is and think about what 80% is. But what you have to pay them is a matter of your contract with them. And clearly, the whole point of this scheme is to avoid you having to make somebody redundant. So if you can't afford to pay a staff member their normal full salary, then you need to have a proper conversation with them, because if the only other option is to make them redundant, then they may well have to accept or be willing to accept a lower salary at this time. Again, this is one of those danger areas where you really need to be speaking to an employment lawyer. So I'm not going to go further into that one. What we do know is the government payments are unlikely to be made until late April. They haven't worked out how this scheme's going to operate yet. So you have to keep paying your staff member, but you're not going to get any money back for the time being. So you need to think about the cash flow implications of that particular issue. The minimum period of furlough is 3 weeks. So staff have to be laid off for at least 3 weeks. Somebody asked over the weekend whether you can furlough a staff member for 3 weeks, take them back on for a week and then furlough them for another 3 weeks. I'm not getting involved in any of that. If you want to play fast and loose with the rules, that's a matter between you, your legal advisors and your accountants. I'd suggest you take care, because as I say, at the moment we haven't seen the final set of rules from the government, and we don't know what HMRC is going to do in terms of policing this down the line. My guess is probably not much because of resource, but I think you need to be very careful to make sure you follow the rules. What you don't want to do is rely on this and then suddenly find that you've done something which puts you outside of the scheme rules. The scheme will initially last for 3 months, but may be extended. And as I say, who knows how long this is going to last for. Certainly, the Deputy Chief Medical Officer yesterday said something around disruption for at least 6 months and maybe longer. So I guess the government may be forced into extending this scheme. They haven't yet designed the claiming or payment mechanism, so we don't know how you will claim it. We know it's coming through HMRC. And obviously, for those of you who are self-employed, so if you're a sole practitioner, owner and director of your own company, the government has announced a similar scheme for the self-employed, but again, they've made clear that the money on that one won't come out until after they've sorted out this staff furlough scheme, so you might be waiting a bit longer. And of course, they've also said that any of us that are self-employed are probably going to end up paying more tax in the future to pay for all of this. So there you go, take with one hand, give with the other. Again, final warning, we haven't seen the full set of rules yet, so please be careful. David, are any questions coming in that we can answer?
A lot. We're getting questions now through 4 different methods: email, text message, Q&As, and comments, etc. And some of them are quite difficult to answer succinctly. So for instance, we've got a good question about what to do if somebody needs to have surgery but is not ready just yet. I think there is guidance out there which I think is probably best referred to in an email. We've had a good question about staff working at home. Do they have to contact their home insurer, the mortgage provider, the office insurer, etc.? Do you have any comments on that, Matt?
Yes, so theoretically, if there are limitations in relation to your mortgage terms and your insurance, then you need to have a look at them. So some may allow temporary working from home, but again, if you're worried about it, if you're worried about the small print in your insurance, then it's worth having a chat with your insurers and your mortgage company. Although my experience, because I've had these conversations myself, is that they're pretty laissez-faire about those things at the moment. And actually some of them are saying, please don't contact us. So check on their websites first, because a number of them are preempting these questions and saying that in the circumstances, things will be allowed. Now, that doesn't necessarily mean, for instance, that work equipment, work files, or other issues will then suddenly be covered under your home insurance policy. But what you don't want to do is invalidate your policy or breach the terms of your mortgage. So it's worth looking at those things. But as I say, some mortgage companies and insurers have been proactive about this and publishing stuff on the website saying we recognise people are having to work from home. So you should be okay.
Okay, there's a couple of really good questions in the chat side, which I'll pick up. One question was back to the earlier question about furlough. We have made most people work at home, but now we want to furlough. Do we need to go and collect their computers, etc., to prove they are not working? My answer is that no, you don't need to do that. I think whether you collect the computers from work is really a matter for you and the risk attached to that. So if we take, let's take an example of an office which has one computer in a fairly vulnerable area, perhaps remove that one. Other computers are not. There's a burglar alarm, there's CCTV, etc. Then as things stand at the current situation, I wouldn't see the necessity, and there's certainly no regulatory or legal reason why you would have to remove the computers. A really good point, which I don't think is quite correct, and it's widely misunderstood. Matt, you and I have been talking about this. One of the comments says, I thought you paid 80% and you reclaimed up to 2,500. Well, it's a very common misconception in our opinion that the furlough scheme is all about employers paying up to 80% of pay. Now, whilst the government guidance does say that, what people are missing, of course, is contracts of employment. And it's very unlikely there will be a clause in staff's contract of employment about furlough, because nobody would have foreseen this situation. Therefore, if the contract of employment says you will get paid X, then the default position is that you'll get paid that figure. So you would actually be paying 100% of the employee's pay. Now, having said that, of course, because of these exceptional circumstances, if you've got your employee's consent to pay 80%, then that would be an entirely different matter. And of course, why wouldn't they say yes? Because the alternative may be to make them wholly redundant. Would you agree with that, Matt?
Yeah, this is a government payment scheme to help get through this. This is not a wholesale statutory readjustment of contracts of employment. So stick with your contracts of employment, negotiate with your staff members. And as I said in the presentation, remember, the point here is that if the only alternative is to make them redundant, then you have to have proper discussions with them about what is affordable. But as I say, keep an eye on this. In terms of collecting the computers, no, I don't think it's essential travel to go to your staff member's house to collect their computer if you've told them they're laid off and they shouldn't be doing any work for you. And I think we ought to trust our staff. Now, of course, you know, if ultimately you have a staff member working from home, they are furloughed and they continue working, then bluntly you're at risk if HMRC start policing this. Because ultimately you're going to have to give a declaration that your staff member was furloughed, And who knows, there may be some audit system down the line, so you just need to be careful. But I certainly wouldn't be worried about collecting computers unless you have a really serious concern about data security, and if it's an unsecured computer, which of course it shouldn't be by this stage.
Let's just take one last question, because the volume of questions coming through the 4 different channels is no way we'll be able to answer those within the hour, and we're 40 minutes into it already. But just one more question. Can trainee solicitors be furloughed, Matt?
Yes. Yeah, trainee solicitors are employees, and we've already spoken to the SRA about this particular point. There is nothing in the training regulations which precludes this. Though obviously, you do have obligations in terms of training them, but they are staff members and they can be furloughed.
Okay, some questions about POA claims. We're going to come to that a little bit later, Matt. So if you can just carry on, please.
So again, for those of you who are DG Legal retainer clients, DG Legal have produced a furlough leave agreement, and that will be sent out to retainer clients after this webinar, as I understand it. David, did you want to say anything about that agreement?
Well, we're usually extremely reluctant to write and share anything which could be construed in some way to be legal advice, because we're not a law firm, we're a management consultancy firm. However, given that these are truly exceptional circumstances, and given that we do have some excellent legal skills and knowledge in our organisation, we felt that it was appropriate for one of our non-practicing solicitors to come up with a template. And we were also very conscious that there's virtually no templates available at the moment because things have just been moving so fast. So what we've done, we've drafted a template. We have sent it at the weekend to a leading employment solicitor. That's Beverly from Crossland Solicitors, and she has added to that template. So what we're going to do is we're going to share that with our retainer clients on an information only basis, and if they feel that it needs adapting for their firm, then they'll need to take employment law advice.
Brilliant. Over to you, David.
Okay, useful software. Well, we thought it would be really useful to share software and other services that we think are working well for us and indeed many of our clients. So firstly, in relation to telephones, we use a telecoms company that has always provided us with free calls to all law firms and all legal institutions, including courts, police stations, etc. Please let me know by email if you want to know more about that company. It's a company we've used for around about 15 years now. Secondly, and you can see in the slide there, a snippet of the DG Legal email checker. So this is a piece of software we designed a year or two ago, and this was in response to many of our clients having the very common problem of staff sending a confidential email to the wrong party. I think most of us have done it at some point. So we do provide this free of charge, not only to our clients, but to anybody that wants this email checker, they can have it. So the idea is that when you press the send button, that box appears and asks you to confirm that the recipients listed below are correct, and any attachments, any documents attached are also correct. So it just slows you down a little bit and makes you think for a few seconds about whether an error has been made. So I reiterate, that's completely free. Please send an email to us if you want to have that software. We use Microsoft Teams internally for discussions and small video conferencing sessions. The chat feature is similar to a WhatsApp group, but is more sophisticated. You can, for example, refer to attached documents. You can also make phone calls using this software. It's free if you are an Office 365 subscriber. So if you do have Office software, please do have a look at it. I think it will improve your productivity. Of course, we use Zoom for larger internal video conferencing because the quality is generally a little better, but also, of course, for webinars such as this one. Now, coming on to our mail, it's a real shame that most practitioners have not come across our mail. I think it's excellent. I think it's the best piece of software I've come across over the last 5 years. What is it? It's a piece of software that plugs into Outlook and has some very impressive features. It enables you to encrypt emails with or without a password or key in Outlook. And it's the only system I've come across that can do this. Encryption, of course, is really important, but it's never really taken off because people are put off by the fact that you have to use a key or a password. Well, this is one system that gets over that hurdle. Clients can reply and send an encrypted email back to you without having the software installed at their end. Rather amazingly, it tracks the journey the email has been on and proves that emails were sent and opened without the receiving party having to click on a consent button. That's amazing or scary depending on your point of view. It has been used in court as admissible evidence in the past. It also enables clients to easily sign and return a document or contract. Probably the most common example for people listening would be client care letters. Now, it's not mandatory to get clients to sign a client care letter, but it's seen as best practice, particularly if you feel the client might misunderstand the instructions or indeed your advice. When sending an email, you can use a side note to tell a colleague something that you don't want the client to see, which can be really useful if you're dealing with difficult clients. One very smart feature is that it can transfer huge files of up to 1 gigabyte. You may recall there was a case in the Employment Tribunal last year where the problem was that the person attached a number of documents to a claim, and the Employment Tribunal server could not cope because the size of the documents was too large. So initially it got struck out. Clearly, if that person had been using this product, it would not have been a problem. And finally, it comes with fraudulent email detection technology. So it warns you if the person that has sent the email is not the same as the actual person. Now, you might be thinking, well, do we receive any financial or other benefit from our mail? Absolutely not. We just think it's a really good product and people should be using it. The cost depends on the number of users, but during the virus, they're offering it free of charge. So go and have a look at that. The UK franchisee is called Frama. But if you want me to introduce you to them and get the product free of charge, I'm very, very happy to do that. Finally, some software providers, such as Bullseye in the crime arena, are offering use of their crime app free of charge. And again, contact me if you'd like any further details. And again, we have no financial interest whatsoever. Okay, now we had the question about financial relief for legal aid practitioners. So Matt, I'll hand back to you to cover that.
So any of you doing legal aid will know that the Legal Aid Agency have been quick to offer staggeringly generous, I'm sorry, I'm being glib here. No, they've basically said that if you're doing legal aid, you can make a payment on account application in civil, and in the Crown Court you can make an interim claim or a hardship payment application in accordance with the normal provisions. So unless they hit us with a package of better things over the next couple of days, and I am hearing some encouraging noise coming out of the rep bodies that the LAA are likely to try to do more. At the moment, it is payments on account for civil certificated work or interim claims or hardship payments in the Crown Court. So nothing new at this point, but obviously if their position changes, we'll let you know. Certainly we're pushing hard for them to, in the context of payments on account, to think about increasing the percentage beyond 75% of profit costs and to allow you to make claims more regularly. And we've also talked to them about reinstating standard monthly payments for firms that might want to do that to help manage cash flow. So they're cogitating, they're thinking about their position. I think they're being stood on a bit by Treasury, which wants businesses, law firms or otherwise, to rely on the things that we're going to come to in a moment. But if there is any movement, we'll let you know. But for now, those are the provisions that are in place in relation to assisting legal aid practices on a financial front. David, any questions on that?
Just bear with me one moment.
Obviously, the guidance on how to do all of those things is on the LAA website. If you're a DG Legal Retainer client and you're not used to either of those, then talk to us. But otherwise, you probably know how to make payment on account or interim claims if you're doing that work on a regular basis at the moment.
No, you've covered the one question that's related to that area, so please carry on.
So let's talk a little bit about the broader support for businesses. Now, again, I don't want to step on the toes of the government or tell you stuff which you ought properly to get from government guidance. So what we're going to do in this section is really just highlight what is available and talk to you about some of the pitfalls if there are any. The first one is the job retention scheme, which we've already talked about. That's the ability to furlough staff and for the government to pay up to 80% of their salary capped at $2,500 a month. So we've already gone through that and I'm not going to discuss it again here. The next one is a deferral of VAT. Now, the government have already announced that VAT from this quarter will automatically be deferred and you can then spread it over the remainder of the year after the next quarter. But I'm led to believe that in order to take advantage of that, if you pay by direct debit, you have to cancel your direct debit because their system will automatically take the money by direct debit if you haven't done so. So again, that was the advice I got from them, and you need to be careful that if you want to take advantage of this. Can I just be really clear here? Deferral is not the same as loan. It's not the same as grant. You still have to pay it, you just don't have to pay it now. And I think one of the things you really need to be careful of in the context of future planning is, of course, whilst you may be able to conduct work for your existing clients at the moment, and whilst some of you in certain areas may be seeing new clients, many law firms will see a significant drop-off in new clients over the next few months as people can't travel or they're just not thinking about their legal disputes. Now, the problem is the money we get in 6 to 8 months' time is for work that we do now. So if you're deferring things or taking loans, you really need to think about your likely capacity to be able to pay them at some future point, particularly if your cash flow is significantly adversely impacted by a lack of clients over the next few months. So do think about how you're going to be able to deal with that. And that's a point that will be critical when we talk about the government business loan solution. The Small Business Grant Scheme is available to businesses in receipt of small business rates relief. It's administered by the local authority. It's a £10,000 one-off grant. And if you're eligible, and obviously the local authority know that you're taking advantage of the Small Business Rates Relief Scheme, if you're eligible, apparently the local authority will contact you. When they'll contact you, how they'll pay it, I'm not sure, but you don't have to apply for it. They will contact you and tell you if you're eligible for it. So again, look out for that one. The other one that you may be thinking of taking advantage of is the government-backed loans. Now, these are administered through the British Business Bank. There are 40 commercial lenders who are dealing with this. The government will guarantee 80% of the loan. Apparently, the bank is expected to guarantee 10% and the last 10% is in the air. And the government will pay the first 12 months interest. But there are a few things you really need to think about. This is a loan, not a grant. It will need to be paid back. Although the government is guaranteeing it, certainly up to a percentage, there's no guarantee that your lender will give it to you. And of course, there will be interest which is payable. And although the government will meet the interest in the first 12 months, if you take the loan over a longer period, which you may have to, you'll need to meet the interest later. Now, for the purposes of this presentation, I approached my bank last week and I asked them to send me details. They were a bit vague because they said the mechanics of this weren't worked out, but they said they would still need to see my business plan, last couple of years' accounts, cash flow forecasting and management accounts, plus a statement of the impact of the coronavirus situation on my business. So whilst this is available, you are still going to have to jump through normal hoops to persuade the lenders to lend to you. And of course, the biggest hoop is to demonstrate to them that you are going to be in a position to pay this back. And so you do need to think about projecting your cash flow and the impact of a reduced number of clients at the moment and what that might do. So again, think about those things. If you are self-employed, as I've already said, there is a scheme which is very similar to the furlough scheme, but the government have made clear that they're going to sort the details once they've sorted the details of the furlough scheme. Of course, as with all things owed to not just the government, but to other creditors, if you can't pay it and you need more time, get in touch and ask them for time to pay. Now, we're told that HMRC will be particularly willing in the circumstances to agree time to pay, but it seems that lots of other commercial lenders and other creditors are willing, particularly if they're able to afford it, to give you time to pay things. But again, remember, time to pay still means you've got to pay it. It just means you don't have to pay it quite yet. Lastly, protection from eviction. The government have announced that commercial tenancies will be subject to some protection from eviction at the moment, but that doesn't mean that you don't have to pay your rent or that you escape the potential for future eviction if you can't pay your rent at some later stage. So you need to think carefully about this. The fact that you might be safe from eviction doesn't mean that you're safe from your commitments under your tenancy agreement. So again, be careful in relation to those. David, are there any questions that are coming up on this?
Well, I'm not sure if you covered this earlier or not, but we got the questions come in about self-employed. Of course, if you're a self-employed person that isn't a director, then of course you're going to be covered by this scheme. But can you just confirm, Matt, that those that are directors of their own company, and that'd be incredibly common in the legal sector, as things stand, they're not really covered, are they?
Well, the thing is, it depends if the company's going to continue to trade. And I think that the difficulty that most of us have, David, most law firms will have this, is because of our existing regulatory and other commitments to our existing clients, whilst we might be in a position to furlough our staff, we generally speaking can't shut our businesses. And therefore, insofar as the furlough type scheme relates to us as business owners, we're probably not going to be able to take too much of an advantage of it, because we're keeping the business open, even if on a kind of skeleton staff, but we're still trying to do things for our clients. So we need to keep an eye on that. I mean, I think we've got to be realistic about this. It's not easy for law firms to shut the doors completely, because we've still got active and open casework. And so whilst we might be able to downsize and take advantage for staff of the furlough scheme, the other scheme doesn't seem to bite if we're not being similarly treated.
Okay, that's really helpful. And even I'm finding it hard to keep up with the email questions that are coming in. But just to reassure one person, yes, we can email all of the slides to everybody. That's absolutely not a problem. Another thing in relation to FAQs, if you would like to send us a query, if something comes to you after this session and you want to send us an FAQ, if you could please send that to alison@dglegal.co.uk, and if you could do that please by the end of today. We'll start working during this afternoon on some of the questions that we haven't been able to answer during the webinar, although I'm conscious we haven't finished yet. But I really do want to try and get this as close as possible to 1 hour, and the sheer volume of questions makes it not possible to do that. But please be reassured that we will answer all of your questions, and we'll do our very best to get that out to you by the end of this week, if not before.
And also organisations like LAPG, if you're members of LAPG, are also working to handle member queries, and I think they may also be launching a non-member service. So there will be places you can get help and assistance, and we'll do our best to be part of all of that. The last section is on business continuity planning. I think when most of us wrote our business continuity plans, we probably hadn't anticipated this scenario. Certainly when I train on the LAPG certificate in practice management, we talk about things like floods and fires with temporary closure of the office. Somebody emailed me the other day who'd been on that course and said, Matt, you didn't teach us about continuity planning for the apocalypse. Now, I'm not entirely sure this is the apocalypse, because as far as I can see, there are no zombies yet, but this is a different situation. And I think it's going to tell us a lot about how effective our business continuity planning was. So here's a few things to think about. Think about how you can cope financially, particularly if this situation continues. And I think that's critically important given the announcements that the government made yesterday in terms of the likely timescales for the lockdown. And of course, even when they lift the lockdown, there may then be a phased return to work. It might not hit everybody, and there may be subsequent lockdowns if the virus then re-emerges. And I can certainly see the potential for a future lockdown in the winter to cope with NHS capacity. So you need to think about the potential long-term consequences of this and how you can cope. If you haven't already done it, undertake some, oh God, I'm going to sound really boring here, some medium and longer term financial forecasting. Think about your cash flow, think about your income and expenditure, and work it out, certainly for 18 to 24 months, because if this is going to last for 6 to 8 months and maybe have slightly longer detrimental impact in terms of staffing and client numbers, then you need to be forecasting and have some understanding of where things are for you. I've talked a lot about supporting your existing clients, but of course you need to think about new clients, because people's legal needs don't go away, and for some of us we are slightly scared about the fact that this is the most significant curtailment of civil liberties that we've seen in peacetime. And I think any of us tracking Twitter and the news can already see that the police are making some pretty randomly crazy decisions about what they think is a crime and what they think isn't a crime. So I think we need to be there. We need to be there for our clients, and we need to make sure you're telling them that you're open and available to them. So make sure you're fully using social media and advertising. I have to say, I've tweeted more in the last couple of weeks than I ever have. So make sure you're getting out there and you're telling your clients that your services are available, but obviously manage their expectations if you're operating on fewer staff because you've got people furloughed. Think about all of the things you've been doing over the last week and the way you're working, and think about what this is telling you about how your firm works generally. I have to say, I've got clients who have in the past poo-pooed moving to paperless working, and who've poo-pooed significant home working, and who've poo-pooed investment in technology, and who would rather have done all of those things differently now. So think carefully about what this is telling you about the way you run your firm. Should you perhaps be increasing the speed with which you move to paperless working? We've already talked about the risk of staff having physical files in their houses. Do you have the right tech solutions, and can you get them in place over the next several weeks or months, just in case this situation continues? And of course, a silly thing, but could you transition to laptops rather than desktop computers? Because that might have a longer term help in a situation like this. And again, if you can, off the back of this, embrace home working and agile working, that might allow you as a firm to reduce your costs down the line, and also to attract staff more broadly. I think it's been a sector-wide problem in terms of recruitment of staff, so you need to be careful about those things. Lastly, just think about what is working and what isn't, and how you can adapt your business continuity plan in future to make sure that that if this happens again, or if a similar situation happens again, you're better prepared for it. David, any questions off the back of any of that?
Yeah, lots and lots, but I'm conscious that we're just over 1 o'clock. So what I'm going to do is we're going to collate all of the various questions by email, text, webinar chat, Q&A, and get an answer out. The one thing I wanted to mention though is it's going to be a lot easier for us if we just copy and paste these questions. Now with the webinar chat and the Q&A, it has your name on it. Now I'll probably just leave your names on it unless you send me an email objecting to that. Looking at these questions, none of them are stupid. There's nothing embarrassing, I think, or too confidential in there. If you disagree, send us an email and we'll make sure that you are anonymized. One last question before we close though. Some areas of law are going to suffer more badly than others through this. Obviously conveyancing is the one that's going to be most affected, it seems. There are other areas which may see an increase in their work. So for instance, wills, power of attorney, divorce, mental health, etc. One question for you, Matt, is this is a time where some practitioners that do offer wills could be writing to past clients. Do you think that's in bad taste, or do you think that's just eminently sensible in the current environment?
I don't think it's remotely in bad taste. I think the reality of the situation is that we, as a society, will lose people that we wouldn't otherwise have lost, and I think it's incumbent on us to help people prepare. Now, obviously, you can choose the wording, but I don't think there's any particular problem with that. I think people need to be prepared. I mean, obviously, I hope it isn't as bad as people are saying, but, you know, when the government stand and make an announcement that if we get away with less than 20,000 deaths, we're lucky, that's worrying. Now, that means that there may well be up to 20,000 people out there who need a will and haven't got one and should be thinking about it. So, again, you know, I don't think it's doom mongering. I don't think it's bad taste. I think it's quite proper to have conversations with our clients and say, we offer this service, because lots of people may well be thinking about this and may well be wanting some help and advice and may well not know quite where to get it in these circumstances.
Okay, Matt, thank you very much for your very hard work and indeed for your work on this webinar today. And thank you very much to the very large number of people that have taken the time out to watch this webinar. So any further questions, please get them into us by the end of play, by email to alison@dglegal.co.uk. And we look forward to responding to you, and we look forward to announcing further webinars as things continue to change. Okay, good luck everybody and stay safe. Bye for now. Okay, Matt, do you want to close the meeting?
David, if I close the meeting, will you lose all of the chat stuff?
I don't think so, but I've copied and pasted it onto a Word document in case that happens.
Okay, I will close the meeting.
Okay, thanks.